Well, thank you for coming along to this afternoon's webinar, which is all about copyright. Before we begin, I'd like to acknowledge and show our respect to the traditional custodians of the land from where you are attending this webinar today and from where we're presenting it. We pay our respects to their elders past and present, who hold the memories, traditions, culture, and hopes of Aboriginal and Torres Strait Islander people. It's on their land that we learn and share our knowledge. We're really fortunate today to have Liesl Fitzpatrick, Senior Manager, Education Licensing at Copyright Agency, with us to present this webinar. Liesl has a passion for education and intellectual property rights, and she's made significant contributions to the education industry through her expertise and leadership. In her current role at Copyright Agency, Liesl promotes awareness of copyright across the broader education sector, and she works closely with over 1,000 private providers, primarily across higher ed, vet, and ELICOS. Thank you so much for joining us today, Liesl. Over to you.
Thank you, Sophie, and thank you also from me to everyone that's taken some time out of your afternoon to join today's session. In my view, it's always important to ensure that you're across copyright in some way, particularly for those who work in the English language sector, just because it does form such an important backbone of what you do. Okay, so today we will be discussing some of the fundamentals of copyright in Australia and how they apply to you as individuals who work within English language providers in Australia. So I'll just take you through some of the areas that we will cover. So I'll give you a brief background as to who we are at Copyright Agency and what we do. I'll cover some of the principles of copyright and how they apply to providers within the English language sector. I'll provide you with some information on how to avoid infringement when you are using copyright protected content in your day-to-day roles. And we'll walk you through some common myths and misconceptions that relate to the use of copyright protected content. I will also give you a brief overview of the Statutory Education Licence for Text and Images, which is the licence scheme that we look after at Copyright Agency, but it is also the primary licence scheme that most English language providers have in place currently that you will be relying on day to day for your use of text and image content. Now, if you do have any questions throughout the session, please feel free to pop them in the chat. And if we don't, I guess, answer them through the course of the session, we can deal with them at the end. So please feel free to do that. The other point I wanted to mention as well is that we will be providing a digital credential for this session as well. So if you wish to access the digital credential, then there'll be an opportunity to do that at the end of the session, which you can then upload to your LinkedIn if you wish. Okay, so let us introduce you to Copyright Agency. So this is the organisation that I work for. We're based in Sydney, and Copyright Agency is a not-for-profit, member-based rights management organisation, and we represent over 40,000 members. So our members are all the owners and creators of copyright protected material in the fields of text and images. So some examples of the types of members that we have include authors, journalists, visual artists, photographers, cartoonists, poets, publishers. So basically anyone or any organisation that owns or creates text and image copyright protected content can become a Copyright Agency member for free. As I say, all of our members are from all around Australia doing all of these fabulous things. Now, in terms of what our role is at Copyright Agency, our role is to, as you can see, to enable the use of text, print, music and images in return for fair payment to the creators and the copyright owners for use of their material. So we do this by managing a number of different license schemes on behalf of our members. And the primary one that we look after, in fact, the original one that we were set up to look after over 50 years ago, is the statutory education licence. So I'm not going to talk about that in too much detail just yet, because I think that it's more important that we talk about copyright and what it looks like in Australia and what some of the basic principles are. So, copyright is effectively a form of intellectual property protection. It's a framework that exists to protect the expression of intellectual property. And effectively, it consists of a number of different rights that are generally exclusively reserved by the creator or the copyright owner. And these include the right to copies, like make copies, and a few other exclusive rights that are effectively controlled by the, as I say, generally the creator, but sometimes there's a different copyright owner. Whoop, sorry, back here. Now, copyright, importantly, protects expression rather than ideas or information. And that's a really important distinction as opposed to other forms of intellectual property protection. So as an example, if you consider a situation where a visual artist creates a lovely oil painting of a particular landscape, the expression of that landscape within that picture would be protected by copyright. However, the idea to create that landscape painting would not be protected by copyright. And also the style used, like the brush techniques or the style of painting, that's not protected by copyright. It's really the expression of that artwork that would be protected by copyright. Now, copyright exists for a number of different reasons, but one of the primary purposes of copyright is to provide economic incentive for creation and investment. So if you can imagine a world where copyright didn't exist, it would be very difficult to convince creators to spend years of their lives writing a book or creating beautiful, expensive artworks, because there'd be no system to recoup the money or the time that they'd kind of spent in developing those works. So it's about creating a flow of money from the people that are using that material to the creators or the copyright owners. And similarly, if copyright didn't exist, you can imagine that it would be difficult to find publishers or people that would want to invest money into developing individuals as creators themselves, because again, there wouldn't be any economics there. So effectively, it is a form of economic incentive. Additionally, copyright provides a certain amount of control to copyright owners or creators, obviously. So again, if you were a visual artist or a writer, you can imagine that you'd want some say over how your work was used. And the copyright legislation in Australia attempts to do that by limiting where materials can be used and in which contexts without permissions from the copyright owners. Okay, so that's what copyright is. Now, I guess the next question is how to avoid infringement. This relates, of course, to how you operate with copyright protected content in your jobs, in your roles, within your providers, but it can also apply in other settings as well, of course. So the really important thing in the first instance is to understand what setting you're in, what you are using and what rules apply to that. So, for example, there may be, a form of copying of a certain work that is permissible if you're just doing it at home for the purposes of your personal research or study, that may not be permitted in your workplace, for example. So it's really important to understand that. And attending sessions like these are really good because they do provide you with some of that really important information to develop your own understanding of the environment that you're working in. It's important to keep in mind what I mentioned before, so the difference between copyright protecting expression rather than information or ideas. So for example, if you were looking at a graph or a depiction of data in a certain way, in a certain image, that image would be protected by copyright, but the underlying data or information may not be, because that's just information. So again, if you understand that, it can assist you in using materials in a way that doesn't accidentally infringe copyright. There are also blanket licenses in certain instances that cover common uses. So the obvious one for you in your roles in terms of what you do is the statutory education license. And there are actually 2 statutory education licenses, but we'll be talking about them a bit later. So that's an example of a mechanism under the Copyright Act that provides you with a certain set of rights, provided you work for a provider that has it in place. And that those license schemes only operate within the education sector. So they're quite specific to what you do. So if you do find yourself in a situation where the use that you want to engage in falls outside of any blanket licenses or exceptions under the Copyright Act, then in order to avoid infringement, you'll need to obtain clearances on a case-by-case basis. So that's always an option. It's always an option to contact copyright owners and negotiate permissions for any uses that fall outside of, as I say, exceptions or blanket licenses that are currently in place. Great. So in terms of what types of works are protected by copyright, copyright protects literary works. So think books, articles, documents, etc. Artistic works, so that can include visual art, photographs, diagrams, images, etc. Dramatic works such as plays and other types of dramatic works. Musical works, which includes musical composition, of course. Published editions, which includes the layout within a certain book, for example. Sound recordings, such as recorded music, film, and broadcasts. So all of those works are protected by copyright law in Australia. So it means that you need to approach the use of any of those works with a certain degree of caution and just ensure that you've got the appropriate permissions in place. And in terms of the exclusive rights that copyright protects, so I mentioned there were a set of exclusive rights. It includes the right to copy. So that includes all different kinds of copying, whether it be physical or digital copying. The right to communicate works to the public, which could be via the internet, via fax, if you're so inclined, or via traditional broadcast as well. The right to perform in public, the right to publish, and the right to adapt. So generally, if you are not the copyright owner yourself, these rights will not be permitted to be engaged with unless you have the appropriate permissions in place or unless you're relying on an appropriate exception under the Copyright Act. Okay, so a couple of questions that come up for us quite often are, firstly, how long does copyright last? And the answer to that, as I say, this is all Australian specific information, okay? So there are different rules in different countries, but in Australia, it does vary between the type of material that you're looking to use. But generally, for text and images, it's the life of the creator plus 70 years. So that's the duration of copyright generally for text and images. And after that period, a work will usually go into the public domain, which means that it's no longer protected by copyright. So if you have a work that's outside of that, that's in the public domain, you usually don't need permission to use it in most settings that are usually limited from a copyright perspective. Okay, and the second question there is, how do we know who owns copyright? And the answer there is that sometimes it takes a little bit of digging. We don't actually have a system of registration in Australia. So in some countries, if you've written a literary work, you'll actually need to register that work via a centralised body. But in Australia, it is automatic. So the moment that you create a work and you commit it to a material form, it's automatically protected by copyright. So if you are looking to contact the copyright owners of a particular work, a good place to start can be to look at the copyright notice. So often a creator or a copyright owner will put a copyright notice at the bottom of their work, which will detail the year that the work was created and the owner of the copyright. So that can be a good place to start. It is important to remember that sometimes there can be multiple owners in a single work. So sometimes it does require a little bit of digging. Okay, and speaking of copyright ownership, this is a good little case study that you may be familiar with or you may have heard of before. And this is the case Naruto versus David Slater. And Naruto is actually the monkey that you can see up on the screen. And this is a case from a few years ago, but it is relevant now for a few reasons, and I'll tell you why in a second. But effectively in 2011, this photographer, David Slater, decided to go to Indonesia to take photographs of monkeys in their natural environment in the rainforest. And what he did was he actually, rather than taking the photos himself, or he couldn't get close enough, so he decided to set his camera up in a specific way in the hope that the monkeys would come and play with the camera and maybe get some close-up photos. And he was in luck because he emerged with this beautiful photo that Naruto, the monkey, took of himself. And that was all well and good, except the photo, David published it, and then the photo went viral. And he found himself in a situation where there was a dispute about the ownership of copyright in the photo. David, he declared that he owned the copyright. However, PETA, the People for the Ethical Treatment of Animals, actually sued on behalf of the monkey, so on behalf of Naruto, claiming that Naruto should be the copyright owner. So this was a case in the US. And where it got to is that the courts in the US decided that because Naruto was not human, he was a monkey, and he took the photo himself, that he couldn't be the owner of copyright. So it deemed that there was a requirement of human authorship in this situation that wasn't achieved. So as a result, it deemed that there was no copyright in the image. So that's really interesting. And how we can apply that today, as I say, this was a US case, but we have similar laws in Australia, so it could be viewed in a similar way. This is relevant when we're talking about the use of artificial intelligence platforms such as large language models like ChatGPT. And there's a lot of discussion at the moment around the output of those platforms and who owns the copyright in that output. And the consensus at the moment, though it hasn't been tested in court fully yet, is that the output probably will have no copyright protection unless it's been contributed to from a human perspective. So unless there's human involvement in the manipulation of that output. So that's where we are. All right, so when is copyright infringed? So infringement occurs when no exception applies. So as I mentioned before, there are a couple of very specific exceptions that apply under the Copyright Act to really specific activities. So if you're using a work and there's no exception and you're using the whole or a substantial part of a work, so it doesn't need to be a certain percentage, it's really just an amount that is an important, distinctive or recognizable part, then you find yourself in a situation where you have infringed copyright if you've engaged in any of those protected activities that I mentioned, so copying or communication or public performance, etc. And if you are in a situation where you or your organization have infringed copyright, then the copyright owners have a number of different remedies. And that includes they can seek damages, such as monetary compensation. They can also seek an account of profits if a work's been made available for sale. And then, of course, an injunction or a stop order. So there are a few different remedies for the copyright owners, but obviously the best situation is to be in is where you haven't infringed copyright, and that's where it's important to be across, I guess, some of the basics that we're discussing now. Okay, so I'll take you through some of the common myths that apply to copyright use, just so we can ensure that you're as up to speed as possible on what is true and what is not in Australia. So myth number one is that material found on the internet is copyright free. And that is still one that comes up quite regularly, even though the internet has been around for a long time now. And that is not true. So material found on the internet, even though it's available for free, doesn't mean that it's got no copyright protection. So it is protected in the same way as physical formats. There are, however, some instances where websites have either specific licensing terms and conditions, which you should be across if you are accessing content from a website, such as documents or even just text of a website or images. So yeah, it is important to be aware of those licensing terms and conditions. And there are instances where websites will stipulate that their material is available to use for free. So you may have heard of Creative Commons licenses. So that's an example of that, where a work is available under a Creative Commons license. And in that circumstance, you can usually use those works for educational purposes. But Creative Commons licenses, of course, only apply to a very small subsection of content on the internet. So it's important to be across that. And with that said, the statutory education license, which we'll talk about in a moment, it does cover website material. So if you have the license in place for your institution, you can rest assured that the content that you're finding on the internet is covered under that license scheme. Okay, myth number two is that educational institutions are automatically allowed to copy 10% of any work. And this one comes up quite regularly. In fact, there is no automatic right to use 10%. You need to be working for an institution that has the statutory education license in place if you want to do that as a teacher or as someone that's developing course material for your students. So it is a good idea to check your internal policies if you don't know already, to check whether you are currently covered under that license scheme. And if you are, then you're good to go. But if you're not, then proceed with caution because you won't have an automatic right to copy 10% of a work. Okay, and myth number three is that as long as we attribute or acknowledge the author of a work, we don't need permissions. So again, this is one that comes up a lot where people say, oh, no, I didn't get permission, but it's okay because I wrote down who the owner was. And unfortunately, that doesn't cut it in Australia. So you should be crediting a creator wherever you're using their work. However, crediting is not the same as getting permission. So you need both. You need to either have direct permission or be relying on a license or an exception, and also be crediting the creator of a work as well. So they go hand in hand. Okay, so I'm going to talk you through this license scheme now, the Statutory Education License for Text and Images, just because, as I mentioned, it's probably the most relevant license scheme or exception under the Copyright Act for English language providers, because it relates to the use of text and image in an education setting. The vast majority of ELICOS providers in Australia have this license in place already. However, it is still worth checking because there are some that don't. So if you don't, then of course you won't be able to do all the fabulous things that the license allows you to do. But either way, it's important for you and for your staff to be aware of the lay of the land, just so that you're not accidentally infringing. Now, we are focusing on the license for text and images today. There is another license scheme that sits under the same legislation that covers TV and radio broadcast. And I'm not going to go into that in a large amount of detail today, but it is good for you to be aware that there is that license scheme that covers TV and radio as well, in the event that you want to learn more about that. Okay, so effectively, this license scheme, it sits under the Copyright Act, which is federal legislation dating back to 1968, although it has been updated a number of times since then. And effectively, it provides a framework of permission, where it provides permission to educational institutions in Australia to allow them to copy and share third-party copyright-protected text, images, and print music without seeking prior permission. So it's effectively a blanket license, and it provides this set of these set of rights, which are usually exclusive. It provides purely for the education sector a permission to use them in that way. Now, the caveats are that there is a requirement in order to access the license that the educational institution agrees to pay a fee for the use. So it's not free. There is a fee payable. And that fee is payable to us at Copyright Agency. We're the appointed collecting society by the Australian government. And the purpose of that fee, of course, is to compensate the creators and the copyright owners for the use of their works. So it's really about compensation, effectively, for the use of these rights that would otherwise be reserved by the copyright owners and creators. The other caveat is that the license only covers uses that are for the educational purposes of the institution. So it will cover you, for example, for the copying and sharing of materials within a classroom setting, either a digital or a face-to-face classroom setting, but it wouldn't allow you to use the same materials in a public-facing non-educational setting. So I'll talk about what that looks like and some examples shortly, but it is limited. All different kinds of educational institutions in Australia are eligible for this license. So it is the license scheme that every Australian university and TAFE and school relies on. And within the private sector, we have individual arrangements with providers. So there's a pretty strict set of guidelines as to who is eligible for this license. Because it's really been developed, exclusively for the education sector. And the permissions are really quite broad for that purpose, because they're in terms of what you're allowed to do without getting individual permissions. The license is, compared to other countries, quite broad, but you are limited to the purpose being educational only. The license sits under section 113P of the Copyright Act if you want some further reading, but we also have lots of information on our website as well. Okay, so in terms of what the license covers, so if you recall, I talked you through some of the exclusive rights that are protected under copyright legislation. So the license provides you with two of those rights. It provides you with the right to copy and the right to communicate works. As I mentioned, it's text and images, so that limits you to literary, dramatic, and musical works. So text, images, and print music. So as an example of the types of materials that would be covered under the statutory education license for text and images, it covers books, it covers journals, newspapers, magazines, website text, documents, reports, images, photographs, visual art, etc. And lastly, print music as well. So it does cover print music. So yeah, it is very specific. And what it allows you to do is to copy and communicate those works. So copying for educational purposes might refer to photocopying either text or image excerpts to distribute to your class, scanning in those same works, into a computer, making digital copies as well, if you need to do that. And communicating generally refers to sharing electronically in this context. So in that situation, it might be sharing material with students via a learning management system. So if you have say you have a scan of a newspaper article that's really relevant from today's newspaper, and you want to share it via a learning management system or via email with your students. They're examples of copying and communication of those works that the license covers. Now, the license is very broad. It covers text, images, and print music from any source and in any format. So there's no way, the creators and the copyright owners can't actually opt out of it. So you don't have a list of works that are included in this license scheme. Everything's in, basically, and the owners and creators can't withdraw their rights. So that's good. It means you don't need to check a list to see if it's if a certain work or a certain book is included. It covers both digital and hard copy content. So if you're wanting to take a piece from a chapter from a book in the library, or use a digital document as part of a course that you're delivering, that will be included under the license. The material can also be published or unpublished. So either official publications such as books and newspapers, or even someone's handwritten letter that they've written to someone that hasn't been published. They're all included under the license. And the content can be Australian or foreign. So there's no limit geographically with regards to where you can source the content. Now, in terms of what the license doesn't cover, so the license doesn't cover TV and radio broadcast. And it's important to be aware of that. So it's really just text, images, and print music. And as I mentioned, for TV and radio broadcast, there is another license scheme, a similar license scheme that's actually administered by another organisation called ScreenRights, who are similar to us, but they look after the TV and radio broadcast component. So yeah, this license, the statutory education license for text and image, does not cover TV and radio broadcast nor YouTube. That one comes up quite a bit. And it doesn't cover audio recordings or musical composition, apart from the print music that I mentioned. So there are, again, in addition to us at Copyright Agency, there's actually another body or a couple of bodies that look after music, one of them being APRA AMCOS, who you might have heard of. And they look after, they have a number of different license schemes on behalf of music. So if you are in need of licenses that cover those types of materials, you'll need to investigate that with either with APRA AMCOS or ScreenRights for TV and radio broadcast. Okay, so within the scope of the statutory education license for text and images, there are some limitations with regards to how much you can use from a particular work. And you can understand the reason for that is that the license is really about achieving a bit of a balancing act for the users of copyright protected content, such as your organisations that you work for, and the owners of the copyright protected content. So I guess it's about achieving a balance in terms of providing the rights that you need to deliver rich education to your students, but also managing the commercial interests of the copyright owners. So there are some limits around how much you can use from a particular work. And the legislation says that the amount of a particular work that you copy or communicate under this license scheme must not unreasonably prejudice the legitimate interests of the owner of the copyright. So that's what the legislation says. Now, in terms of what that means, I've got some guidelines for you. Because the legislation isn't very prescriptive. And effectively, this is where we get to the 10% rule, which I mentioned earlier. So basically, if you work for an institution that has this license in place, the guidelines around how much you can use are 10% or one chapter for a text. So whichever the greater, 10% or one chapter. Images in their entirety from a digital source. And for images from physical sources, generally you need the surrounding text. That's the guideline. For text works that are taken from anthologies, such as collections of short stories or poetry, works in their entirety can be used, provided they're no longer than 15 pages long. And for articles from periodicals, such as newspapers, journals, and magazines, it's one article per issue, unless there are multiple articles on the same subject. So if you want to share a newspaper article on something that happened over the weekend, and there are a few articles within the same paper, you can actually rely on the license to use multiple articles from that same issue. And then lastly, the guidance around works that are not separately published or commercially available for purchase in a reasonable time is that you can use up to the work in its entirety if you need it for educational purposes. So what that means in practice is if you had a situation where you found a fabulous textbook, for example, that wasn't available in Australia, and the publishers aren't looking to make it available in the next period of, say, 6 months, then the license would allow you to copy and communicate that work up to in its entirety for educational purposes. So that's a good one to be aware of. So yeah, these are guidelines, and there are certainly circumstances where the rules might be slightly different, and it really depends on what you're trying to do in terms of how much you're trying to use, whether it's likely to impact commercial sales for the publisher. So if you have a situation where you need your students to use 80% of a textbook and that textbook's available for purchase in Australia, then your students should probably be purchasing that book as a core textbook. And this license is more about providing supplementary readings. So it's about supporting, I guess, the core materials that you're providing, which might be via a textbook or via other materials that you've developed yourselves. Okay, so yeah, in terms of the benefits of the license, as I mentioned, it certainly reduces risk associated with copyright infringement, and I'm sure you can see why that is the case. It does provide you with that ability to enhance the quality and currency of any supplementary readings and content that you are providing to your students. Particularly for materials like periodicals, newspaper articles that come out every day. It can be difficult to get permissions in time if you go down the route of obtaining clearances on a case-by-case basis. So it does enable you to act quite quickly with regards to sharing that type of content. It is a blanket which covers your whole institution. And of course, it contributes to a strong creative economy as well. So it comes back to one of those original principles of copyright, which I talked about being an incentive for creative development of content. So it's about contributing to the creators who make your lives easier as educators because they're able to keep creating content when they receive a financial contribution from the creative sector, from the education sector. Okay, so some examples of activities that are covered under the license versus those that are not covered. And this is an important distinction. So if you work for a provider that has this license in place, the statutory education license, of course, it will permit you to upload a copy of a book chapter onto a learning management system to be shared with students as part of a course of study. So that's really clearly an educational use. You're providing it to your students as part of a unit of study that they're enrolled in with you. On the other hand, if we jump over to the right-hand column, generally, if you wish to upload that same book chapter onto a public-facing website for anyone in the world to access, that's outside of the scope of the license. So it won't cover you for that. Example number 2 is making photocopies of a newspaper article to distribute to students in class. Again, that's very clearly within the scope of the license. However, if you wish to scan a newspaper article about your institution to share on your institution's social media page, talking about how great you are or what great things you're doing, that falls outside of the scope of educational purposes, and that's really a marketing purpose. Example number 3 is copying an image from a Google image search to be included in a class PowerPoint. So again, the license covers images from any source in the world, including the internet, including Google Images. So yeah, that would be covered that falls within the scope of the license. However, if you wish to use that same image on a brochure that you're printing to advertise your institution, that won't be covered by the license. So you'd need a direct permission, or in most instances, to use an image for that purpose. And then lastly, example number 4 is combining various readings and images or diagrams from various sources to create a course pack to be provided to enrolled students. So that's very much within the scope of the license, and we have a lot of providers that rely on it for just that, for collating selections of resources to support a course that they're delivering. On the other hand, if you wish to sell third-party text and image resources for a profit, that would not be allowed under the license. So it's okay if you're just providing it to your students as part of their course that they're studying with you, but you wouldn't be able to on-sell for a profit. So hopefully that all makes sense. Okay, and then AI. Now, I'm just going to talk briefly about AI because obviously it's quite a hot topic at the moment, and it will be for some time to come, I expect. It really is a bit of a moving beast from a copyright perspective. So there are lots of things happening around the world, which you may or may not be aware of with regards to copyright and AI. There are lots of different, I guess, concerns about large language models and how they're being trained and whether it's copyright compliant, etc. So that's one side of it, which we won't go into today. But I guess the other question that you might have is what the copyright implications are of using tools like ChatGPT and other large language model platforms as tools when you are developing content for your class or even with your own workflows. So the statutory education license will actually provide you with permission to upload third-party text and image works into ChatGPT or other AI tools, provided that, so for example, if you're wanting to, use a tool such as ChatGPT to generate some questions for a class based on an article, it will allow, the statutory license will allow you to upload that article to generate those questions. So you'll effectively have that permission to do that, provided your institution has the statutory education license in place. The caveats are really the same as any other use, that any of the output from that activity is solely for educational purposes. So all of those purposes that we were talking about before, and that it's not subsequently used for any other activity. So it's really, I guess that's what you need to be aware of. So the first thing really for you within your individual providers is checking that you have the statutory education license in place, which, as I say, most of you will. And then if you know that you do, you'll be aware that you can rely on it for the uploading of content into those kinds of tools. So basically, and the other thing as well is being aware of the output, which I did touch on briefly before. But as I say, the consensus is that straight AI output will probably not have copyright protection, but it really does depend on a case-by-case basis. And it depends on how much a human has been involved in the output. So for example, if you're using it as just a tool, the platform, or if you're really manipulating it and making it your own and adding your own creativity to it, in that case, it may be protected by copyright. And in fact, you may be the copyright owner. So it is a little bit grey at the moment. And if you are wondering on a case-by-case basis as to who owns the copyright in a specific piece of AI output, you may need to get legal advice because, as I say, it is quite case-by-case and specific at the moment. But hopefully that's a helpful starting point. Okay, so in terms of the statutory education license, I mentioned that most English language providers have it in place already, and it's basically an agreement between Copyright Agency and your organisation, whereby your provider agrees to pay equitable remuneration to us, and then our role is to distribute that money to the creative sector. And we have, as part of that, a remuneration agreement in place as well, which dictates the terms of that remuneration. And there is also a requirement, which comes from the Act itself, from the Copyright Act, that if required, your organisation will provide us with information on usage as we need it from time to time. So you may come across a situation where we request that you be involved in a survey. And that might mean providing us with information on the types of works that you're using and how regularly you're using those works. And the purpose of any of those surveys is really to enable us to fairly distribute the money that we collect, which is a mammoth task, as I'm sure you can imagine. So if ever you're called upon for that kind of survey, I guess that's the context. It's really to provide us with data to ensure that the appropriate creators and copyright owners are being paid. Great. And if you do happen to work for a provider that doesn't have the license in place, which, as I mentioned, is unlikely but does happen, then we have a simple application form via our rights portal, which you can see up here, whereby you can apply for the license, and it's all pretty straightforward and instant. In terms of the fees that are applicable, so the license scheme it runs under a rate card that applies to the whole sector. And this isn't just the English language sector, it's the same rate card that applies to VET and to higher education and other types of providers as well. So for individually licensed institutions, there's a fee based on a percentage of revenue for for-profit providers, which is 0.25% of gross receipts. And that's subject to a minimum fee of $334.92. And for not-for-profits, there's a fee based on level of study per student. So that's effectively how it's structured, and it's always based on retrospective use. Now, if you do work for a university or a TAFE, and obviously for a school as well, we actually have separate rates that apply under sector-wide agreements. So these rates won't apply to you because you've got a kind of a separate arrangement which are negotiated centrally via the Department of Education and via Universities Australia as well. Great. And if you do need any more information on the license, as I mentioned, we've covered, I guess, a few basics in this session. There's always more that you can learn. And copyright is a very big area. There are a couple of places that I can point you to that are up here. So if you do work for a provider that has the statutory education license for text and images in place already, then feel free to go to our Knowledge Hub, which is that address that you can see up on the screen. And there are lots of resources and information for staff internally with regards to the guidelines and other types of limitations around the uses under the license. So feel free to navigate there. We also have information on our website more generally. So that's not just education, but also for other sectors as well. So have a look at our website, particularly if you don't have any of the licenses in place currently, because that will be able to, I guess, direct you more holistically to the most appropriate license for your setting. The other destination that I would highly recommend is the Australian Copyright Council, who you may be familiar with. They are a not-for-profit organisation who provide information and advice on copyright matters to all different kinds of organisations in Australia. So if you go to their website, you'll find lots of free resources and some paid-for resources that go into a lot of detail about all different kinds of copyright matters. So I highly recommend their website. They also have a free legal advice service that specifically deals with copyright related matters. So if you need a copyright lawyer, that can be a good place to start. And they have lots of regular information sessions that they run as well. So I highly recommend that you check out their website and their resources as well. Great. So thank you very much. If we do have any questions, now is probably the time to do them. And I have got up there on the screen as well the LinkedIn badge if you wish to access it for completing this session. Feel free to scan your code and you can access it there. Now, did we have any questions come in, Sophie?
I can't see any yet, but if you do have any questions for Liesl, please pop them into the chat.
The other thing we can do as well, I will be at the English Australia Conference next week, which is an event that I'm very much looking forward to. And Copyright Agency will have a booth at the conference as well. So if you do have any questions and they arise after this session, feel free to bring them to me then, because I'm really happy to deal with them one-on-one in that setting as well.
Okay, great. So I think there's a question in the Q&A box, which I'll read out. And then I think, Leanne, you've said you've got 2 questions, so just pop the questions into the chat as well. I can only see one in the Q&A. So the question that we have is, if you're a self-employed teacher teaching at an educational institution which has the statutory education license, are you covered by this when working for them? Or do you need your own license?
That's a very good question. And if you are employed by that, even on a casual basis by that educational institution that has the license in place, you are covered under that license. So that's good to know. The challenge for individuals that are moving between providers is being aware of the copyright setup of each provider. Because of course you might be if you're working for various providers, you might work for 2 that have the license and 1 that doesn't, which can provide an additional challenge to you. As I mentioned, in Australia, the vast majority of English language providers do have the license in place. But of course, they should be doing, I suppose, their due diligence in informing you if you are working for them as to whether they have that set up, just so that you can ensure that you're doing the right thing, of course, because you don't want to be doing the wrong thing by your employer either.
Okay, thank you. That's clear. So we have a question in the chat. My
Yeah.
understanding was that a teacher can't use a YouTube teacher clip without the institution having the screen rights license.
Yeah, good point, Leanne. So I'll talk about that in a little more detail if you'd like. So the way that it works in Australia, there are a couple of questions, I suppose, that you need to consider before using a YouTube clip in class. There is an exception under the Copyright Act for the playing of videos in class that only applies to not-for-profits, believe it or not. So if you work for a not-for-profit organization, you can actually play YouTube videos or any other video in class, publicly perform that video, okay? If, however, you work for a for-profit organization, the exception does not apply to you. Okay, so schools, for example, can rely on that exception because they're nearly always run on a not-for-profit basis. In the English language sector, the majority are run on a for-profit basis, so that exception won't be available to you. So if you wish to play a video in class, one option is to look at the source of the content. So you mentioned the screen rights license. The screen rights license, which I obviously mentioned a couple of times as well, it only covers material that's been broadcast on television or radio in Australia. Okay, so if you're wanting to use a YouTube video in class and you work for a not-for-profit, sorry, a for-profit, the screen rights license will only cover you if that YouTube video has been broadcast on television. Most YouTube content has not been broadcast on television, of course. A lot of it is user-generated content that's been uploaded by the user. So most of the time, if you wish to play YouTube videos in class, you'll actually need permission from whoever uploaded the video. And you will need to be aware of any other underlying rights in that video as well, for example, music or other types of rights. So it can be a bit of a minefield. We can talk about it more at the conference if you want to come up and grab me at the booth. But it's not necessarily a blanket coverage if you have the screen rights license in place for all YouTube videos. It's really just material that's been broadcast on television.
Okay, yeah, it's definitely complex.
Yeah, these areas always are.
There's another question about the 10%.
Yeah.
So is the 10% in a single copying event?
Good question. So, and I think what is important here is to reiterate that 10% is a guideline, okay? So it's not a hard limit. Is it 10% in a single copying event? Basically, it's the purpose of that guideline or that limitation, however you wish to phrase it, is to ensure that you're not compromising the commercial interests of the publisher, okay? So what they don't want to see is you providing lots of different chapters from the same book to the same set of students, okay, over the course of a unit of study. So if you were doing that, even if you were doing the copying on different days, you would likely be in breach of the license. So it's really about ensuring that if you have a set of students that need the majority of a book, for example, they should be purchasing that book. That's kind of where it comes to. If that material, if you're wanting to purchase, if you're wanting to copy 3 different chapters from a book and provide it to 3 different sets of students, it's not an issue because you're not providing those chapters to the same set of students. So they're not able to cobble together the book effectively without purchasing it. So I guess that's the way to frame your thinking around it. And as I say, there are guidelines, not limitations, but it's really about asking yourself whether the publisher is going to be likely to be impacted negatively commercially if you're engaging in the activity that you're doing.
Okay, yeah, makes sense. There's a couple more questions about YouTube videos.
Always
Firstly,
popular.
yeah. Is it okay to share a link to a YouTube video on an LMS?
Yeah.
And is it different for profit versus non-profit providers?
Good question. And this is a very good follow-up question because it provides another angle. So generally, the view in Australia is that a URL is not protected by copyright. Okay, so if you're wanting to play the video in class, there are copyright implications. If, however, you're sharing a URL with your students, there's no copyright protection in that URL. So if you want to share a link to a YouTube video, so which is just the URL via a learning management system with your students, that will generally be fine from a copyright perspective. Of course, there are all kinds of other things to consider, for example, the student experience when accessing that content, etc. Because sometimes videos are taken down or whatever. But from a copyright perspective, that's a good solution if you don't have that permission, and that will limit your infringement from a copyright perspective.
Okay, and would that be the same for a URL to a reading or a blog post?
That's right.
Yep, okay. There's another question about YouTube. Can I ask students to watch a YouTube video on their own devices during class or for homework?
Yeah, so if they're watching it on their own devices, it's not a public performance. So again, if you're directing them to a URL, a specific URL, you're not, as I say, it comes back to those protected rights that I was discussing. You've got to ask, am I copying this work, which is the video in its entirety? Am I communicating or publicly performing this work in its entirety, or even a portion of it? And if you're just sharing a URL, then generally that won't be protected by copyright.
Okay. I think that might be it for questions.
Excellent. Well, look, certainly some
really
good
follow-up questions, though. Thank you to everyone who provided them.
So yeah, if there are any other questions that arise over the next few days, as I mentioned, I'll be at the conference next week, so I'm perfectly happy to elaborate further on any of those areas. And obviously we haven't, as I mentioned before, we covered off on a portion of this because it is a huge area. So there are, always emerging areas, but also quite specific parts of the Copyright Act that we can't explore in complete detail in short sessions like this. So always open to have a chat if anyone wishes.
Well, thank you so much for sharing all of that content and those examples, which were so relevant to us as educators. And I think you answered a lot of questions that people will have had, when in their working lives. So thank you for kind of picking out those interesting case studies and questions as well.